application and the appeal in the name of DH.
Yes, good morning, Mr. Chairman.
My Lord, good morning. May it please the Court, I represent the appellant, along with Mr. Travers, who appeared below, who sits behind me. We have, for the local authority, the first respondent, we have Miss Wills Goldingham, King's Counsel, along with Mr. Howard, who appeared below. And we have, for the seventh respondent, A, yes, Mr. Aidan Vine, King's Counsel, and Miss Hoyle behind him, who appeared below.
Yes. Now, does that mean that the children's guardian is not represented today?
Mother, father one, and guardian, I'm told, have been excused by this court.
Right. I'm sorry, I'd forgotten in relation to the guardian. We've seen the skeleton argument from Miss Sanders.
Yes.
And we've also seen the short documents filed by mother and father one.
Yes.
Can I just say, as this is a case involving children, as the parties will of course know, there will be no reporting of the identity of the children or their family members, and those of us who are in court will do our best to make sure that we adhere to the system of anonymisation, which was, I think, adopted by the judge and is very serviceable for this purpose. Could I just alert counsel to the fact that if there are any breaches about that, it's quite understood that it's difficult sometimes, particularly for those who've been at trial, but it almost always happens when people are reading things out.
Yes.
So if we could try and maintain that sort of discipline. Could I just check for the moment whether any of the family members themselves are present in court?
My client sits at the back.
Yes.
I hope out of sight of the camera.
Yes, absolutely, that's very appropriate.
Yes.
Good. Well now, Ms. June, before you get going, can I just deal with your application, which is simply that you put in or the local authority, sorry, not your application, but the application for the skeleton argument. In the way of things, we read what was sent in order to see what's there. If it seems to me, speaking for myself, that if there's any particularly difficult or problematic issue that arises in relation to that application, then we'll deal with it as it comes along. But for the moment, is it comfortable to everybody that we just get on with the paperwork that we've got?
Yes.
All right. Well, in that case, I need to say nothing about that application. Yes. No.
Thank you, my Lord. I would, if it pleases the court, like to start topic one for our submissions is a brief analysis of the judgment of His Honour Judge Richards, King's Counsel, which is the judgment that is by the decision of Her Honour Judge Skellorn, King's Counsel, being reopened. The headline of this topic for us in our submission is that is a solid judgment, not capable of being appealed on the evidence before that court, and that the submission creep that has happened here before Her Honour Judge Skellorn, that seems to suggest that it is but for lacunae in the rules, such as the local authority not having locus to appeal that, it is an eminently appealable judgment, is not correct. It is a solid judgment founded on the evidence. And I point firstly to the judge's findings in relation to the mother based on documentary evidence. He found that the mother was a witness who was not credible, she was evasive, and she was prone to exaggeration. I don't know if my Lord wants, and the court wants as I go along, the bundle references to these references, if it would assist.
I think probably the best thing is if there's one we particularly want to look at, we'll ask you.
Thank
the fact we don't ask you doesn't mean it's not an interesting reference, it's just that we've got it in our minds.
Understood.
I know that my ladies will ask if they particularly want a reference, but I'm well aware of where in the papers that
Thank you.
is to be found.
And understood. So, not a witness who was credible, evasive and prone to exaggeration. Based on the documentary evidence, she told the police, 14th of May 2019, that A, tells lies when she is in trouble, that my client, F2, the appellant, was a kind, loving and gentle man who had a great relationship with the children. She was not aware of anything untoward. To Judge Richards, at trial, confirmed that she had not spoken to F2 when she made those statements and confirmed the truth of her statements. To the Child Protection Conference before that trial, she reported A as having lots of problems, including stealing, underhanded and lying, suspended from school, constantly seeking attention, constantly playing off one parent against another. Now, by the time of the Judge Richards hearings, this court hearing and decision, this court will know that M's position had changed, and she was then saying, and using terms such as my client F2 had been grooming A, but struggled to substantiate that and corroborate that. She struggled to explain documentary evidence put to her. And turning to A, as opposed to M, when turning to A, the judge found that A had given a number of different versions about what had happened. They included whether or not there had been an actual physical assault, whether the event complained of was continuous or separated by A leaving the room, her own acceptance in the Crown Court's transcript of being untruthful, her own evidence about what she was wearing or not wearing at the time, and the evidence that goes back to M that A was prone to dishonesty, was Judge Richards' conclusion. And so we respectfully submit to this court that those solid and evidence-based findings corroborate and support the decisions, the fact-finding decisions of that court, and that the reopening of those findings must, and we'll come on to the legal test obviously in due course, must emphasise the need for the search for something new, something tangible that has changed in the evidence in relation to A in terms of the reopening of those findings. The second topic, if I may, is I just wanted to list some of the concessions made by the parties before Judge Skellorn in the judgment that is under appeal now. That is important for both the parameters of the parties' position and the parameters and boundaries of the issue that was before Judge Skellorn. So the first, and I don't use the word concession pejoratively, I use it because Judge Skellorn used it, but the first position of the local authority recorded in that judgment is that the local authority accepted that a reopening of facts could not be allowed on the mere making of new similar allegations by the same child or a different child. They cited, and Judge Skellorn agreed, with a floodgates type argument, as well as a principled type argument.
Can you just pause at this point?
Yes.
Take a note. What is it that you say could not, was accepted, could not lead to reopening?
The mere making of a new similar allegation by the same or a different child. That's paragraph 35 of the judgment.
Just pause there. I appreciate this may be a byway of your main argument, but
Not at all.
I mean, let's take this case for example. A makes an allegation against your client, and at the end of two sets of proceedings, one leading to an acquittal, one leading to a no-finding outcome. But I don't think it would make any difference to the purpose of the argument if the finding had been an exoneration.
Agree.
It's the fact there was a final decision.
Yes.
Now, what one can see, and it's what exists in this case, that one has to view matters on the basis that A said something once, and in the context of these proceedings, she's still saying it.
Yes.
The same thing.
Yes.
But the reason that I was pausing on this was because, let's suppose, instead of the incident which A alleged had taken place, she had made a different allegation. You know, suppose something that had happened at a different time in a different place.
Yes.
Was that caught up in what you were describing the local authority's position or concession to be?
As I understand the concession to be, it is the concession relates to, on the terms of the judgment of paragraph 35, new similar allegations. So subsequent to the exoneration or binary return of
But
nil.
I appreciate this is not your position, but your narrative of what you say the local authority was at one point saying.
Yes.
But can it be right that the conclusion of a proceeding in relation to one allegation means that a different allegation of a similar nature is also caught up? I appreciate that in other circumstances there might be a Henderson argument that if you bring an allegation, you've got to bring your allegations. But in terms of issue estoppel, even if the local authority were making that concession, can they have been right in law to do so?
It cannot and should not, in my submission, be right that that is a generally applied principle. It is right on the facts of this case.
Right. Well, so can we? I said that it might be a tributary of your submission because this is not the case that we've got.
No.
But I think for the moment I would take some persuading that suppose a child had made an allegation, that had been investigated and determined one way or the other, that meant that one way or the other that was the end of any allegation that child might make against that person.
I understand, my lord.
Right.
And while we're in the tributary, I don't need to go that far.
Yeah.
I go so far as are relevant, as we say, to the facts of this case and the allegation of this client.
Well, as a matter of fact, you say the local authority were making some quite sweeping concessions, as you put it. Back to you, does that make any difference?
It does make a difference because it led, we say correctly, Judge Skellorn to accept that concession. And she did not go to D's allegations interplaying with A's allegations and or a propensity argument. She rejected that, as we say correctly, as relevant to this reopening of A's allegations.
Right. This you say is at paragraph 35.
That's at paragraph 35. The concessions at paragraph 35. The discussion, I was going to come on to it later, but I'm happy to jump to it now. The discussion.
No, I want to just make sure I'm following this. This is 35.
Paragraph 35 is page 53 of the bundle.
Yes.
Just the simple recording, this is, of the local authority concession. Paragraph 35, the very bottom of that page. Does my lord have it? It's the line that starts firstly.
So that's what the local authority were then saying.
Yes.
And does the judge then say more about that?
The judge says more about that. At paragraph 76, page 72, which is a long paragraph, but really towards the bottom of page 72. I'm really looking at, I'm not trying to stop my lord reading that entire paragraph, but I'm really looking at 4 lines up from the bottom of 72, to have any notional potential relevance to A's allegations is how the sentence starts. And then that passage.
Bottom of paragraph 72 or bottom of?
Sorry, page 72, bottom of paragraph 76.
Oh, 76. My fault.
To have any...
Thank you.
I suspect it's not helpful for me to read out loud.
All right. That was one concession.
That's one concession, my lord. Thank you. The The second concession I point to is at paragraph 38 of the judgment, bundle page 55. Sorry, I'm now doing that thing that I said I wouldn't do, giving the bundle references, but it was that the local authority concedes that it would be quote-unquote unthinkable for the family court to routinely consider reopening facts found on the basis that a child had gained maturity and was quote-unquote now capable or willing to give evidence. We again submit that's a correct concession, if concession even be the term, and one that was adopted by Judge Skellorn and is an important boundary and parameter to this argument on these facts. The point being that this would expose families and the system to repeat litigation because of the passage of time and the gaining of maturity and or confidence in young persons who firstly did not want to give evidence and now do. That might apply to very many cases, and we're back to a floodgates type argument.
Repeat the paragraph number that you stated.
I'm so sorry. I have this at paragraph 38.
38, thank you.
But the critical word is routinely, isn't it?
Yes, respectfully agree. I respectfully agree.
Yes. That's the second one.
The third one is that the local authority, no party, challenged the decision in the complaints about the decision-making process of Judge Richards. No one challenged or sought to challenge the re-W decision that I should not give evidence, and that is because my lord will know, the court will know, that A at the time was saying did not want to give evidence, and that's very important, obviously, in any re-W consideration. No challenge to that is to be found at paragraph 38 if that's necessary. In passing, can I just refer the court to the judgment of Judge Richards, in which Judge Richards noted that all of the parties agreed the position during the time of the evidence before that court. That's paragraph 12 and 13 of that judgment. Yes. At 89. That might not be terribly important for the court's consideration.
Well, I do want to just...
Forgive me. That's at bundle page 89, paragraph 12 and 13, Judge Richards saying all parties agreed. It's less obvious, I accept, from that judgment as to why they agreed, but the reason that they did agree, and Mr. Travers has confirmed this for me,
yes,
is the wishes of A, which are not obviously determinative but are very important, as my lord doesn't need me to say. Well,
there were two issues about that. One was whether she was going to be giving evidence, and the other was whether she's going to remain as a party.
Indeed.
And our understanding, I think, is that whatever happened when that decision to discharge A,
yes,
there isn't a note of any reasons that were given at the time.
There is not.
And that was the 22nd of May.
Yes.
Decision.
Can I also say at this stage that not only is there not a note, but there was no appeal?
Yes.
From any of the parties interested then?
Mr. Dugan, I'm conscious I'm going slightly away from the point you're making. My apologies. But
not
just as it arises on paragraph 12, where Judge Richards says he's going to view the full ABE interview when it becomes available, it follows, as I understand it, but please correct me, that in fact no parties were then able to make submissions on the adequacy or otherwise of what was contained in that interview.
Not my understanding of how a trial would work. If complaint is wanted to be made of the process of ABE and the fairness of that process, a common complaint for a respondent in such a trial, one does not need the witness to be live to do that. That's a submission that is opened commonly.
No, forgive me, the fault is mine. I didn't make my point clearly. The short point is the judge at a later date viewed the ABE interview. Yes?
Sorry, yes.
When he did so, or immediately after, it wasn't then able for the parties to make submissions as to the adequacy or otherwise of the contents of that interview.
It was open to the parties to make submissions, and commonly is.
It was.
The judge viewed it, agreed the re-W position that A would not give evidence,
yes,
and then went to trial. And the trial is on the basis of the encapsulated evidence of A in that ABE, and submissions are commonly and routinely
right,
made
thanks
in
very
relation to that.
No, can I just pick up my lady's point, because
I'm sorry, it might be.
this is only in relation to just establishing what the factual situation was. That in fact, it was a May hearing, not an April decision. At that stage, the judge had not been able to see the ABE interview.
Oh, forgive me.
That was I think that was the foundational point, because it wasn't obviously available, because he said he would view it when it was available, and he did in due course. But the point that then arises is that by the time he came to view it, A wasn't there to comment on it.
Indeed.
I mean, I hold in mind that, as it were, all of these are not necessarily your mainstream points. They go to one of your grounds.
Indeed.
One or other of your grounds. But in this case, I'm not sure whether, without rereading Judge Richards, he had the transcript of the criminal trial at that stage. He may have done, but one of you will know, whether at that stage the judgment reveals that he'd read the criminal cross-examination.
At the time of discharge?
Yes.
My lord, I'm sorry, I don't know. We'll check, and might I revert to the court on that?
All right. I think that was the point that arose.
I'm sorry if I've misunderstood, my lady.
I obviously didn't make it clear to you.
I'm sure it's me. So my third concession or point in terms of parameters was the non-challenge of the re-W decision.
Yes.
Well,
and of the discharge decision.
And of the discharge. The fourth brings us to the discharge. It was conceded by the local authority in the court below that that was an appeal point.
I mean, it could have been appealed.
That it was. Paragraph 40 of Judge Skellorn's judgment.
I haven't understood it was conceded by the local authority below that...
That it was an appeal point, not a reopening point.
No, oh, I see. Well, they weren't trying to reopen. I mean, those proceedings had ended. They weren't trying to reopen the decision about discharge. They could have appealed it. They didn't.
Well, they could not have appealed it because they didn't have locus, because they weren't in the Richards proceedings, Judge Richards proceedings. So when the case comes before Judge Skellorn,
yes,
on the reopening,
yes,
and the local authority complain about the discharge of A before Judge Richards,
yes,
they concede to Judge Skellorn,
yes,
that is an appeal point.
An appeal point by whom?
By someone who was disgruntled or not happy with that decision, and someone who had locus. And I respectfully agree with them. In my submission, I respectfully say that they are right about that. That is an appeal, not a rehearing point.
But your main point is that it's not something that Judge Skellorn was entitled to take into account, isn't it? I mean,
that is what I'm coming to.
That's one of your grounds of appeal. That
yes.
That she shouldn't have been interesting herself in this.
In these appeal
because
points.
This was all dealt with, not appealed, and there it is.
Yes. And the short point I'm making is that on this, the local authority agreed at the time. And Judge Skellorn agreed at the time.
But if that was to be put right, it would have had to have been appealed.
Yes.
Right?
And finally, the position of all of the parties before Judge Skellorn.
But I'm sorry to interrupt, Mr. Chair. Was the local authority conceding that the only way in which it could be put right was by an appeal? Or was it simply saying it was a point that could have been put right on an appeal by one of the parties who at that stage had locus to appeal?
Well,
because they're slightly different points, aren't they?
I only have paragraph 40 of the judgment, and I did not represent the local authority, obviously. And paragraph 40 reads, Mr. Hard rightly...
I've read it.
I'm so sorry. So it's my interpretation of that paragraph that in terms of the distinction between whether we should reopen or someone with locus seek to appeal, the local authority were saying they agree the discharge of A is an appeal, not a reopen point. That's how I read that. But I accept that others might read it differently, and I accept that there's a different interpretation.
It might not necessarily be a binary choice.
Exactly so.
Yeah. Okay.
I respectfully agree. But my Lord Justice Peter Jackson is right that our global submission on these parameters and these submissions is that the complaints about procedure before His Honour Judge Richards are both appeal points and are then hauled below the waterline when one analyses the evidence that that judge had before him. And we go back to the solidity of those findings. On the evidence then, because that is the judgment that Judge Skellorn has said should be reopened.
Your submissions inevitably throw up interesting thoughts and go along, and I really don't want to derail you. But
not at all, my lord.
The nature of a reopening jurisdiction does not depend upon the solidity or flimsiness of the previous decision. That any reopening question approaches matters on the basis that there is a decision which has stood. If it was appealed, but the process worked itself out, and there's a decision. That we're not, surely are we particularly concerned with deciding, with saying that in order for a decision to be reopened, it has to be shown that there was something wrong with it. I mean, you're very entitled, and I take your point, to say this was, if your submission is correct, a very solid decision by Judge Richards. Nothing wrong with it. Nobody appealed it either in midstream or when the thing was finished. You're very entitled to say that, but the reopening jurisdiction applies to applications to reopen decisions of rock solidity.
Respectfully agree. But I'm so sorry.
In a sense, it may be relevant to the consideration that Judge Skellorn had to make, but Judge Skellorn has to take the decision as she finds it, doesn't she? And to draw from it any things that she thinks are or are not relevant to her job. She's not, as she says, acting as an appeal court from Judge Richards. And the fact that Judge Richards' decision may have been rock solid on the information that he had, it doesn't really provide you with the answer to the reopening question, does it? As a matter of theory.
As a matter of theory and as a matter of principle, I respectfully agree with everything my Lord has just said.
So it's case specific.
It's case specific.
Yeah.
And what I'm coming to eventually is there is nothing new here.
Right.
And therefore there are not solid grounds.
Yes.
Which brings me neatly, I hope neatly, to the legal test. And I very much hope, because we have very much in mind the terms of the permission granted by my Lady Justice Eleanor King.
Did you have point 5? Sorry, we interrupted you, and you said, I've got 5 concessions.
I think I have.
I'd written 4, which was the 4th, is that if the discharge was wrong, it would have to be appealed.
I'm so sorry. Thank you, my Lord. I haven't got to 5. Right. Forgive me. Thank you. The 5th and important point is the position of all of the parties recorded in the earlier judgment of paragraph 24, judgment of Judge Skellorn, that A seeks to advance no new evidence or allegations against F2. That it is the same case as heard by Judge Richards.
So that makes this a simpler set of facts than it might have been.
Yes, indeed. And so, coming to the permission granted by Lady Justice Eleanor King and the terms in which that permission was granted, and the desire, as that learned judge saw it, for this court to perhaps review the decision of RL, I hope this court isn't going to think that I'm ducking that invitation to review. It's a matter for this court. But I'm addressing the facts as they apply to these children and my client and the care proceedings as they are ongoing.
Well, were you now going to, as it were, touch on the law?
Yes.
and what I think we'd be helped by is to understand what put it in whatever way you like, what is the nature of Ground 5? What is Ground 5 saying on your client's behalf?
Ground 5 is only saying that it is legitimate and, in fact, in some cases necessary to look for the new. And Mr. Justice Mostyn in RL said that, and he was following authority that we'll come to, if I may. And that is not new or even controversial. If RL then goes further into grounds of public policy and the interplay between jurisdictions and civil and criminal and family, that is not, in my respectful submission, an area I am going to seek to go to unless I can attempt to assist this court. So I say that expressly, knowing the terms of the permission granted. I say that this appeal on these facts can be determined without me having to go there on behalf of this respondent.
Well, now, I think we're going to need to be clear about, in no particular order, whether you're saying that the judge applied the wrong test, what test you say the judge did apply, and to seek your help, because this appeal offers the occasion for us to think about this, as to what, if any, difference there is between the RL formulation and the other cases that,
yes,
that are mentioned. Are they different? And
yes.
if so, does it matter? Either generally or in this case. So very right and of you, and we're very happy that you should identify specifically what Ground 5 is saying for your client in this case, because you're not expected to deal with more than that. But we do need to know what your broader position is in relation to this matter of principle. So please take it in your own way, covering it as you wish.
So point 1 on legal test is that we agree and in fact aver and submit that the correct law is found in the authorities listed by Judge Skellorn at paragraph 25. They include Re-E and Re-CDT. They also include the older cases of Birmingham and H and ZZ, all of them central core law to reopening decisions. Happy to go to the authorities bundle, but I know they're well known to this court. Also in that paragraph of law Judge Skellorn relied upon is the case of RL. Brought to the attention on behalf of F2 by Mr. Travers for F2 at the time. I positively submit that Judge Skellorn encapsulated the law correctly by citing E and CDT, my Lord's guidance and summary of the reopening jurisdiction in those cases. I am going to go on to submit, if I may, that having encapsulated the law correctly, she applied it incorrectly.
Is that then by reference to RL?
That is not by reference to RL.
By reference to the...
By reference to her, but Judge Skellorn's judgment.
Right. Now, what then has RL got to do with this?
In terms of this appeal,
yes,
and on these facts, what RL has got to do with our case is a recent emphasis on the look for the new, which is correct, because there is not new here.
So it has got quite a lot to do with our case, because really that is your core submission.
Yes. Yes, it is.
I appreciate you have other submissions under 1 to 4.
Yes, it is.
But
in a sense, my lord, can I put it like this? If RL hadn't been mentioned by Judge Skellorn, I would not be addressing the court about RL. I'd be addressing the court about E and CDT and the court,
yes,
the Court of Appeal authorities on what is the reopening jurisdiction, and I'd be making that submission. I'm conscious that the reason that I'm standing here is because of Lady Justice Eleanor King's decision on permission.
And so it's the emphasis on the new.
Yes.
It's you do not have, crudely, a dog in the fight in relation to legal theory.
Exactly.
In relation to cross-jurisdictional issues.
Exactly so. I wouldn't want my lord to think I wasn't interested in all of that, but in terms of this client and his appeal, we don't run the appeal on that basis, which I can see might be problematic given the way permission was granted. but permission has been granted, and here I am.
All right, well, you can say anything you like about those matters, but essentially the point at which you are aiming is that there was nothing new.
Exactly so.
Right. And so we'll need to see what the authorities say about that.
Yes.
As being a requirement.
Yes.
And see what he said in RL about that.
Yes.
All right.
Authorities, RL, and then, if I may, Judge Skellorn and how that learned judge dealt with the issue. So forgive me, my lord, might I just pause for a moment, because I think I've probably covered those submissions. So can I go to the new?
Yes.
And the authorities that support the idea that the new is relevant to the reopening jurisdiction, and that on that issue, Mr. Justice Mostyn in RL was right to talk about the new. And the first authority is my lord's Re-E Children Reopening Finding of Fact 2019. Now, this is in the passage I wanted to refer the court to is both in Judge Skellorn's judgment and, of course, in
Can we go to the authorities bundle for this purpose?
Yes, of course.
Mind.
Not at all. So Re-E starts in the authorities bundle at page 33.
Yes.
And it's where my lord cites Mrs. Justice Hale, as she then was in Re-B. And we find that at page 40 of the authorities bundle. And it may be better to go to Re-B itself, which is at 62 of the authorities bundle. I'm so sorry, I have an incorrect page citation.
Can we stay with
E
for the moment, or do you want,
Yes,
or would you like to restart with going to B and then we'll come back to E?
My hesitation, my lord, is that I think my page citation for where it is in E is incorrect. I have it at page 40. It's my lord's passage citing Mrs. Justice Hale.
Yes, it's a paragraph 28, page 40.
I cannot see it for looking at the moment. Yes, I'm so grateful.
Yeah.
But yes, exactly that.
Now, would you rather go to the Re-B decision itself?
Not for my purposes, my lord,
Okay.
unless it would help the court.
No.
And it's over the page at page 41 of the authorities bundle. It's that passage that starts with the indented paragraph 3. My lord is still citing Mrs. Justice Hale. Above all, the court is bound to want to consider whether there is any reason to think that a rehearing of the issue will result in any different finding. Might I jump on to the court will want to know A, B and C, and C is whether there is any new evidence or information casting doubt upon the accuracy of the original findings. So new. And that obviously is Mrs. Justice Hale, as she then was cited with approval by this court more recently, and we pray and aid that reference to new. And then, I should pause, and then the next authority I would seek to refer to is Re-W.
I'm just
Yes, of course. Forgive me.
running through it as we go. So, whether there is new evidence or information is one of a series of considerations.
Yes,
It's not a test.
I agree.
It's a factor. Yes. Now you were next going to.
My lord, can I just pick up on that point? Not in a sense to be combative, but just to make a submission that, of course, I respectfully agree with the way my lord has just put it. It's not a test, it's a factor. But in a case in which there is nothing new, the public policy considerations about the finality and, of litigation and the desire to achieve that must increase in my respectful submission. That must be given more weight, because why are we relitigating when there's nothing new? So I respectfully agree, and would add what I hope is a helpful gloss would be my response.
She also says that subparagraph little a, whether the previous findings were a result of a full hearing in which the person concerned took part and the evidence was tested in the usual way. So that too is a factor.
It is, and it was usual in this jurisdiction. It is absolutely usual for a re-W decision to result in the young person not giving evidence and for there to be an analysis on the paper of the ABE interview. That is normal and usual.
All right.
And I respectfully, I'll stop there. I say that's normal. In fact,
Okay.
it could be argued that because of the advent, this might be unnecessary, but because of the advent of re-W and the introduction of children giving evidence, in fact, the unusual is the child giving evidence, notwithstanding that that's been over a decade now in practice.
Well, it doesn't really seem, does it, as if Mrs. Justice Hale was thinking about children specifically, or maybe not even at all. She was just thinking about evidence.
Yes.
But there we are. We have to interpret it.
Can I respectfully suggest as well that in a common sense, why should we undertake that litigation again? Common sense might suggest there has to be something new. This is not difficult, because litigation should have a finality, notwithstanding all of the other factors, a finality if possible. And unless someone is coming along to add something to the previous evidence or give different evidence, it's a very important factor, the absence of newness.
So, just because you've expressed it as it were conversationally,
Forgive me.
You are or you are not saying there must be something new. You're just saying that the absence of something new is an important factor. Which are you saying?
Here,
Yeah.
on these facts, it should be the determinative factor.
No, I'm asking at the moment how the principle is to be stated. Are you seeking to make the submission that there cannot be a reopening if there isn't something new?
I'm not seeking that in cases beyond this one, on these facts. So I'm agreeing with the way my Lord has put it to me earlier, that it is a factor and even an important factor, but it is a factor for consideration. I'm not contending for a wider or stronger, more strongly expressed principle. But on these facts...
Well, you'll come to the...
I'll come, thank you.
It's doing the law at the moment.
Yes. Now, I'm sorry to say, I think that re-W is best found, still in the authorities bundle, page 96.
Just for my benefit, I'm not making a complaint here that the electronic bundle I have here is not the easiest I've known to work with, and so is it possible for us to extract from re-E what the court actually said about this point, or are you going away from re-E? The new...
What Judge Skellorn said about re-E?
No, this court said about... I mean, we're in re-E, and I think you were about to head off for re-W. I just wonder whether we can, while we're in re-E, find out what re-E has to say about this.
Yes, by all means. My Lord, forgive me, I have been working not particularly from the authorities bundle for this because I'm agreeing with Judge Skellorn's treatment of re-E.
Yes.
And Judge Skellorn's treatment of re-E is at page 47 of the current, not the authorities bundle. And there is a full treatment and full recitation of the principles, the first stage. Page 47, which is paragraph 26 of that judgment. And it's paragraph 3 of the re-E authority. Is the court assisted by me headlining those principles of re-E? I'm happy to read.
No, I'm just trying to remind myself because
Yes.
there have been a number of these decisions.
So the first...
The extent to which the decision in re-E went beyond or summarised what was said in Re B and in the subsequent first instance decisions.
My Lord, the part of Re E that I say Judge Skellorn correctly summarised at paragraph 1, the considerations of public policy that will be well known to this court, the public interest in the end to litigation.
Sorry, we're at cross purposes still. I'm really engaged on a very modest mission, which is to identify as clearly as we possibly can what we said in Re E. I think I've got at the end of the first stage, sub-paragraph 4, it appears to be, as we happen to be looking at it in another judgment. These establish that at the first stage, the applicant must show that there are solid grounds for believing that a rehearing will result in a different finding. Mere speculation and hope are not enough. Now, that clearly is a takeaway message from Re E.
Absolutely.
And it wasn't invented in that case. It's
no, indeed.
It's been said a number of times previously.
It was, my Lord, citing other authorities in Re E, including Re B that we've looked at,
Yes.
and coming to the paragraph 3 at the top of page 48 of Judge Skellorn's judgment. Above all, the court is bound to consider whether there's any reason to thinking. And can I just point out and flag up B at the end of that?
Thank you.
The court will want to know, if so, whether there's any ground of which the accuracy of the previous finding could have been attacked at the time and why, therefore, there was no appeal at the time. And C, whether there's any new underlining new evidence or information.
Yes. So A, B, and
Citing
C
Re B.
all come into play.
Absolutely.
Right. Okay, now, sorry, you were going on.
Thank you, my Lord. I was going on to the second authority on the issue of new, and the second authority is another authority of my Lord's, Re W, page 96 of the authorities bundle. I believe paragraph 28, which is page 106. And I hope my Lord will forgive me for seeking to read my Lord's words back, but paragraph 28 at page 106 of electronic bundle 105 of the paper bundle, it is rare for findings of fact to be varied. It should be emphasised that the process of reopening is only to be embarked upon where the application presents genuine new information. Now, the reason for me citing that is in support of Mr. Justice Mostyn in RL, if I need to, and in support of the idea that new is an important factor.
Yes?
My Lord, I think that takes me, for my purposes, if it pleases the court, to RL itself. That's at page, the first authority in the bundle, page 2 electronically. I hope the head note is helpful. The legal principles, if it be better than the head note, start at paragraph 27, but the part of the head note that I'm seeking to rely upon and say is acceptable because of those previous authorities reads in this way: solid grounds would normally only be capable of being shown in special circumstances where new evidence had emerged which entirely changed the aspect of the case and which could not with reasonable diligence have been ascertained before. That's the head note. The principles start from paragraph, oh, this is Riel still, the principles start at paragraph 27.
So there are two elements to this formulation.
Yes.
New evidence well, three really. Entire change
Yes.
and no reasonable diligence.
Yes.
Yes.
I note my lord hasn't referred to special circumstances. I respectfully
Well,
agree.
of course, that's a special circumstances. That's 4.
On special circumstances, can I just suggest that Mr. Justice Mostyn might have meant on special circumstances was the re-W. It's rare to reopen. You need something new, which we've looked at.
I think he meant that was a hallowed phrase.
Possibly.
Running back through some older cases.
Yes.
Now, Mr. Justice Mostyn, if one stays with the head note,
Yes.
clearly considered that what he was saying was not exactly the same as what this court was saying.
And I respectfully agree with him. It's not.
Not the same.
It's not the same. It's not the same because of the further legal principles enunciated, such as the interplay between jurisdiction, the need for the family court to, I think he uses the phrase, not be on a desert island in terms of the other legal jurisdictions. But those, I hope I've made clear, don't form part of my submissions on appeal. Those are the public policy.
No, but I don't think that what's being said, if we conveniently look at the last 2 lines of the head note, is about that. That it's not about the legal theory. It's that there's a general law test and there's a more liberal interpretation.
Yes.
And so I think you were accepting that they're not the same things.
I do accept that they're not the same things, and I do accept that RL has gone further than E and CDT, particularly E, because that's relevant to this case, and obviously the summary of the reopening jurisdiction as given by my lord in re-E. And I do accept that he's gone further, but that...
I'm not so concerned, speaking myself, about the historical stuff. I'm just concerned about the formulation of the test that is to be used by judges. We've identified special circumstances, new evidence, entire change, and entire change of aspect, and reasonable diligence as being 4 elements that have been set up. On your submission, which of those comfortably sit within re-CDT, re-W?
It's difficult to make them comfortably sit.
Well, some of them might. I mean, for example, you mentioned special circumstances. I appreciate that had a meaning for
Yes.
Justice Mostyn.
Yes.
But it's been said that these occasions will be rare.
Yes.
But no need maybe to reformulate that.
Respectfully agree.
New evidence, you place weight on what I said in re-W.
And E and Mrs. Justice Hill in B, yes, my lord.
Entire change of aspect.
That is clearly language beyond E and CDT and my lord's earlier decisions. I don't know if it would be helpful, my lord, to go through the legal principles later on in the RL judgment. They started.
It may well be. At the moment, just before we set off,
Sorry.
I just want to see where the runway was.
Yes.
Before you embark on it, and the sort of lad and marshal without reasonable diligence.
Yes.
New or already there.
New.
Right. Okay. So, with that sort of general view as to how this fits or doesn't fit with the other authorities.
Yes.
Where does that take you?
It takes me along the same track already, I hope, enunciated, that I am not, in this appeal on these facts, seeking to uphold RL, except that the reason that it's in Ground 5 and the reason it was referred to Judge Skellorn was the emphasis on the new, and on the new, Mr. Justice Mawson is not saying on anything, forgive me, new. But his legal principles, learned judge's legal principles, start at paragraph 27. My Lord said earlier that the court might be assisted to run through what is said in RL, but I do that in an attempt to assist, not because it's central to my appeal.
Right, and so it's been very helpful to hear how you've put this, Mr. Chairman, because going back to what Ground 5 says,
Yes.
Ground 5 was drafted, and I quite understand why it was, that the court was wrong to reopen the findings of fact where, quote, no new evidence had emerged, etc.,
Yes.
reference RL.
Yes.
The ground could have been drafted without causing problems for your case. Simply the court was wrong to reopen the findings of fact where no new evidence had emerged.
It could have been. But I say that without seeking to criticise anyone behind me. But
No, I don't either, because in a sense, gifted this formulation, I quite understand why it's used.
Yes.
But in a sense, it's not necessary for your argument.
Indeed.
It would then move away from being an argument based upon legal principle to simply being one saying that the judge got the balancing exercise wrong in that important respect.
Indeed.
No. You were going to go to the text of RL with that in mind.
So the legal principles, my Lord, I hope not to just canter through them, but look, Mr. Justice Mawson at paragraph 27 sets out issue estoppel and the essential features of issue estoppel. The doctrine at paragraph 29 of res judicata. Paragraph 34, although Hale J mentioned that the doctrine of res judicata should not apply to children's cases, she accepted instances where a rehearing would be allowed, would be rare. Mr. Justice Mawson, further on in paragraph 34, draws attention to Lord Justice Waite's characterisation of issue estoppel as a mere example of procedural rules capable of being arbitrarily imposed. In my respectful opinion, says Mr. Justice Mawson, paragraph 35, the inquisitorial nature of a proceeding is not a good reason to disapply this rule of fundamental importance. He cites a divorce case at paragraph 36 and notes that in that case, the inquisitorial nature of the proceedings did not prevent the application of the estoppel in that case. He then comes on to re-E at paragraph 38. Court of Appeal principally concerned with the procedural question of how in continuing proceedings a challenge to finding of fact might be made. Could it be by way of an appeal, or could it be made to the court of first instance? Mr. Justice Mawson says that my Lord held that the latter course was permissible. And then says, thus in re B would apply in a true issue estoppel situation where the later case not only had the same party, but precisely the same issues as had previously been litigated. He deals at 39 with my Lord's judgment in relation to the fundamental change because of the implementation and creation of the family court. And then at paragraph 41, importantly and perhaps centrally to RL, paragraph 41, the test of my Lord in re E, says Mr. Justice Mawson, when correctly understood, is not or should not be materially different to that obtaining under the general law. That a party can, it is important to understand that under the general law, notwithstanding a bar of issue estoppel, a party can exceptionally challenge an anterior judgment in fresh proceedings at first instance, in certain clearly defined circumstances. The authorities identify, paragraph 42, two types of cases where it's allowed fraud and new facts is the second one. And then at paragraph 43, Mr. Justice Mostyn again explains my Lord's judgment in Re E, as it therefore seems to me that Jackson LJ's test of there must be solid grounds for believing that the earlier findings require revisiting ought to be interpreted conformably with these exceptions if a divergence from the general law is to be averted. Now, my Lord, I on behalf of this client, concede and accept that these debates about divergence from general law on the way we put his appeal are not necessary for his appeal. So if I'm to make further submissions about that, they will not be central to the appeal. But I recognise, I recognise and submit that the family jurisdiction is looking at and implementing a very different set of often constantly moving facts. And the jurisdiction on reopening is, I would submit, necessarily different to what might be the norm in civil and criminal proceedings.
This has been referred to in the paper sometimes as dynamic.
It has, yes, indeed. And so I repeat, forgive me if it's becoming tedious, the repetition, I repeat, I cite, pray and aid and rely upon, particularly Re E and Re CDT, my Lord's reopening jurisdiction cases, and continue to say it looks to us as though Mr. Justice Mostyn has gone further. Whether he's right to do so or not is for this court.
Yes.
Paragraph 44, this interpretation would have this interpretation being the aligning of the family jurisdiction with the other jurisdictions would have the advantage of ensuring that family law is not seen as a rogue castaway marooned on a desert island, conducting itself without regard to the norms of the rest of the legal universe. It's obviously for this court and not me to say whether that is correct, whether that is even
right. So
a desire.
It would have been open to you, Mr. Tuan, to, as it were, put on this cloak
Indeed.
and champion this analysis,
Yes.
and saying whether or not it was an argument made to Judge Skellorn, had she correctly understood the matter and had she applied RL, then she was bound to arrive at the conclusion we argue for.
Yes.
That's not your route to success on this appeal.
It is not. It is not.
Right, and for paragraph 45, we ought to be applying the general law.
Yes. So if it pleases the court, I would propose to move on from law
Yes, thank you.
to Judge Skellorn, analysis and reasoning. And this is at paragraph 71 of that judgment, forgive me. That is page 68, electronic 69 of the current bundle, the core bundle.
Yes.
Now, the submission I'm seeking to make here is that having correctly stated the principles from this court on the reopening jurisdiction, that the learned judge in this case applied them incorrectly. Because by the time we get to paragraph 71, E and CTT have been cited in the judgment, and the passage in E in particular that we've already looked at has been cited in full. I take no issue, with respect to the judge's formulation about 7 lines down that starts after the italics. In my assessment, the truth or falsity of A's allegations would be an integral important component of the global threshold exercise the LA now intends to place before the court. That is obviously correct in circumstances where they had not been adjudicated on, and I respectfully agree. It would not be our application on behalf of this client to in some way sever the indictment, as it were, on the threshold.
This is on the basis of the availability, potentially, of arguments about propensity.
Indeed.
Which are not easy necessarily, but
Indeed.
And can't be decided any time ahead of time. But you're accepting that, forgetting about the previous proceedings,
Yes.
the truth and falsity of A's allegations could be relevant to the truth and falsity of D's allegations.
They could be.
They could be.
Yes, I am accepting that. But I am saying that the intervening act, as it were, it might be unnecessary to use that phrase, forgive me, the importance of the judicial finding of a court of competent jurisdiction hearing all the evidence and giving a judgment of such solidity is not waved away by a local authority who comes along and says, we weren't in those proceedings, we don't have locus, that's irregular, and we need to be allowed to put our best threshold case forward. That, in my respectful submission, I mean it respectfully to my learned friend who sits in court who made that submission, I really do. That is, in my respectful submission, a bold approach by a local authority, because the system is that local authorities are in the tramlines of previous findings of the court. That's just the system. That's what.
So you say that you say that the fact that the parties are different in that respect is irrelevant, or it's not a game changer.
It's not a game changer.
It can't be considered to be irrelevant, can it?
It can't be irrelevant, but on consideration, it's not important, because the local authority are making procedural. Forgive me. I hope they'll forgive the language. They're quibbling with the procedure in following a full fact-finding hearing, which the court took into account all of the evidence.
So would it be helpful for us to analogize this by saying, let's suppose there was no local authority here, but that A had dropped out as she did before the fact-finding first. Let's suppose these were still private law proceedings involving the parents, but the allegation had been made in relation to D.
Yes.
You with me there?
Yes.
Right. So if one was to strip away the local authority's argument, if that's what it is, and simply say that here we, having dealt with A as seemed, along comes D and apparently makes an allegation in the same format of proceedings, mother and father. That you say leads to what conclusion?
In this case, in this case, the submission I'm seeking to make is that D is not quote unquote new in relation to A's allegations, and is not therefore and cannot be solid grounds for reopening A, whether or not the local authority are there.
Right, so the argument then is that the new information has got to relate to A.
Or establish a propensity which it cannot hear, I say, and Judge Skellorn was right about that. But yes, sorry, my lord, I'm overcomplicating the answer to that. Yes, it's got to relate to A, because we don't get to propensity here.
So the fact that as it were, the situation of the family may have changed in various respects, including the allegation of D.
Yes.
You say takes the matter nowhere if nothing has changed in relation to A.
On these facts, yes, I do say that, because the problems that there are elucidated and set out by Judge Richards with the allegations haven't changed, and there is nothing new about those allegations. The only new thing, and I don't use the term new in a formal sense under the authorities, the only new thing is that A now will give evidence. And I say that simply cannot be.
No, it's not that she wants to give evidence. If, just taking at face value what we're told, she wants to give evidence in a context in which it's said that her half-sister has had a similar experience.
Yes.
So you characterise that as nothing's changed in relation to A.
Yes, and I say...
But there's another possible interpretation, isn't there?
Well, I say that nothing has changed in relation to A because the allegations in relation to A, whatever D is saying, the allegations in relation to A haven't changed. It's accepted by all the parties that there is nothing new about those allegations. They're the same facts as Judge Richards heard. So if my lord is to say that because of the fact of the D allegations that impacts A, I concede that if we didn't have the Judge Richards earlier decision, we'd hear them all together. But the D allegations do not impact on the A allegations. And that is because...
Well, then I think we need to correct our note, because you previously told us that D is not new information in relation to A. It's really in relation to A's allegations.
Forgive me, that's what I meant.
Yeah, well, I'm sure you did, yes, but
Forgive me.
I mean,
Yes.
It's clearly, in some sense, new in relation to A, because A is in a different circumstance.
Yes.
So it's in relation to A's allegations.
And they're clearly new, small n, if I can put it like that, as opposed to capital N. They're not new as in meeting the test under the authorities that we've looked at in terms of what is new evidence.
Right. That's helpful.
And that is because, my lord, we are not, in my respectful submission, in propensity territory. Because the D allegations are being litigated, and the trial, my lord will have seen, is listed in June. 11 days as a time estimate. They will be litigated and they will be found upon. Either they are litigated, and that doesn't alter the static A allegations because she has not added any new detail. She's just saying, I will give evidence now. Or they're not litigated and there's no findings. And we don't get to propensity evidence on either a findings basis or a lesser propensity basis. And what it all comes down to, my lord, is that none of this is new and therefore cannot be solid grounds for reopening.
Could you just, in different words, express your propensity point? Because I thought we'd established that if we forgot about the previous proceedings, there was at least a possibility that a finding in relation to A might establish propensity in relation to D, or indeed a finding in relation to D might establish propensity in relation to A. I think you were happy with that, if there was no intervening history.
Well, my lord, the propensity...
Well, I thought that was something that we had... Closed, but I mean, I'm happy to reopen it, but it would seem in a sense to be fairly obvious. And I think it's something that Mrs. Justice Hale mentions in Re B.
Yes.
That these decisions are very important, because if you get stuck with a finding of being an abuser, that can cause tremendous downstream consequences. Similarly, if abusers are not identified,
yes,
downstream consequences may follow.
Yes.
So I don't think we would take much persuading that somebody who had been found to have committed one act of abuse might present a risk to another child. But were we on solid ground in that?
I'm no longer sure, my lord. Can I attempt it again?
Yes, because I had parked that.
With apologies, if it's me.
Because I thought you took no...
I
thought it was where you said you took no exception to the first unitalicized sentence of paragraph 71.
Yes. D's findings, in any event, and whatever the decision of this court in relation to A, are being litigated.
Yes.
They will either be proven or they will not be proven.
You seek to have them proven or not proven without regard to A. Further, you seek, and your client would seek, as the judge found, to say there is a fixed point, namely that there is no finding in relation to A.
Absolutely. And at the moment, of course, there is not. That the propensity is not open to the court because of that tether.
Of course it isn't in that context.
In that context.
Yes, but if both were being litigated together, either because the judge's decision is upheld or because the intervening proceedings had never happened.
Yes.
If both were litigated together, then clearly there's a potential for a propensity argument.
Well, there is.
Both ways.
That there is a potential, although I venture to submit that any trial judge hearing this will have to analyse
Oh, yes.
the allegations
With immense caution.
with immense caution. And we know the problems that have already been established in relation to the A allegations, whatever the outcome of D's allegations. And so, in my respectful submission, it doesn't take it very much further.
Right. But that's not a point of principle.
No.
It's a question of working through.
Indeed. And can I go to, can I stay with, forgive me, I've lost it, Judge Skellorn's paragraph 71?
Yes.
That learned judge's treatment of this. The learned judge is saying, about 10 lines up at the bottom of paragraph 71, A's allegations are at the very heart of the parental separation and the dysfunctional dynamics which have. In my respectful submission, that is to elide what would be the more normal case management if there had not been the intervening decision of His Honour Judge Richards. That takes us no further. Well, that takes us no further about whether there are solid grounds for reopening. It may be correct, but it takes us no further. Paragraph 72, the paper or intellectual merits of a new wide fact-finding exercise cannot, of course, be determinative of the application. Something further would be necessary. The learned judge goes on over the page at the top of the next page, which is bundle page 69, top of paragraph 72. The wide powers of issue management are irrelevant here. Instead, focus must fall on whether there is any reason to think that a rehearing of the issue will result in any different finding from that in the earlier trial. Although many decided cases on reopening, especially those relating to alleged inflicted injury, are predicated upon new evidence, the test does not strictly require new evidence. And my Lord, I've already accepted my Lord's formulation that new evidence is a factor as opposed to a strict test. So no complaint there. Evolving or emerging information or knowledge can suffice. The learned judge goes on, that is one item on the list of potential features which I assess to be guidance and non-exhaustive. I therefore understand RE-CTD concepts of reason to think and solid grounds to be capable of being established with or without new evidence. But in either scenario, there must be a proposed changed litigation landscape with identifiable and tangible markers of something new to hear or to be factored into. Forgive me. At paragraph 76, in considering whether there is any new evidence or information casting doubt upon the accuracy of the original findings, I have noted that in several passages of their written Skellorn it has been suggested that the fact that A now wished to give evidence and was prepared to do so may amount to new evidence. And then goes on to say, I do not accept that scenario. That analysis would fall foul of the mere hope speculation barrier. As recorded above, the LA conceded orally that it would be unthinkable for the family court to entertain the reopening of judgments on the basis that a child witness had gained maturity. And then at the very bottom, this is Judge Skellorn, to have any notional potential relevance to A's allegations, these allegations would have to be proved to the civil standard. And a court would have to be satisfied that they add something by way of propensity or similar fact evidence by reference to the case law as to what is permissible. Those are complex areas of law. It is very far from certain that the proof of either child's allegations would be accepted as having corroborative or probative value for the other. And can I add in, although this is an attempt at an analysis of Judge Skellorn, can I add in and repeat, with apologies, the solidity of the evidence that was before Judge Richards? The local authority conceded through Mr. Howard a floodgate situation may arise should allegations post-dating a fact finding become an acceptable reason for allowing the reopening of cases. And in my respectful submission, what Judge Skellorn is saying there in terms of the tramlines that the court was faced with is correct in that there will, in this case, on the local authority's case, there will either be a finding or not. So we don't need to get into the R against P propensity type arguments. they will be looked at separately, and the judge is saying there, this is a complex area, and they might, in her mind, the propensity might not apply, whatever the findings. She'll look at, that learned judge will look at them separately. No complaint from on this appeal in my submissions. Paragraph 77 is the nub of it.
76 is passes muster from your point of view.
It does. 77, about 5 lines down, there are grounds to consider that the non-findings need to be revisited. And this is, in my respectful submission, the nub of the decision that Judge Skellorn reached was a case management decision as though we were ignoring the Judge Richards decision. The learned judge says, a reopening will allow an unhindered consideration of the alternative basis threshold with a view to achieving a reliable global factual matrix for the children. Unimpeachable if there hadn't been that earlier decision, and that does not go to solid new grounds, given the way the judge had set out the tramlines above. Because the judge, that learned judge, is rejecting the notion of using propensity to say it's new, and is then saying unhindered alternative basis threshold, which is unimpeachable in case management terms without the previous judgment. And that, in my respectful submission, is the nub, and it's the nub of our complaint and our appeal, is that our respectful complaint, is that having accepted a lot of the tramlines and having accepted a lot of the arguments that were before the court, the learned judge ultimately says it would be better to hear it all together without explaining that, without explaining why, beyond case management.
In fact, I haven't been counting, as it were, and I'm not asking for you to sign a blank check, but is there anything before 77 with which you severely take issue in Judge Skellorn's analysis?
My Lord, I wonder, can I put it, I'm trying to use more concrete language, but I wonder about the treatment that Judge Skellorn gave to the new evidence point and the changed litigation landscape, whether that is what Lady...
That's 72, is it?
That's 72.
But, I mean, this may or may not be a helpful exercise, but, and, you know, if while others are speaking you want to reflect on it, it would help if you were able to point us to any paragraphs apart from 72 and 77 that you say show the judge falling into error.
Certainly, my Lord, and I understand.
Because at the moment we're understanding that really 77 and to an extent 72 are your concerns.
And can I also say, my Lord, I was coming to 74, which is the procedural quibbles of the Judge Richards decision.
Yes.
The discharge of status.
Yes.
But I hope...
Sorry, we were
I hoped I'd already
we were
covered that.
on the sort of main point
Yes.
at this stage.
Yes.
And 74.
74.
Right, well, by all means add to this as you go along, but
Thank you, my Lord.
that helps for our thinking.
And so, my Lord, can I attempt to summarise? In these circumstances, these allegations are not new for A. A has nothing else to say, and there is no new evidence beyond that heard by Judge Richards. That the mode of delivery of her evidence might be different, but that is not enough. My respectful submission should not be enough.
It's not enough in its own.
Thank you. Respectfully agree. I'll move on. On its own, the gaining of maturity and the desire to give oral evidence. And so, does any of this make any material difference to the outcome? And it's the Mrs. Justice Hale phrase cited by my Lord in Re E, above all, is it likely to change the outcome of the Judge Richards decision? And I say not.
So why do you say of the Judge Richards decision?
Because it's the reopening. We're looking at the reopening of his findings. Is the reopening likely to change? Is a permissible, in fact, central test under Re E? Is it likely to change it? And I say not in these circumstances and on these facts. Partly because of the solidity and the evidence that has not changed, including documentary evidence, by which I mean the mother's statement to the police, the mother's statement to the Child Protection Conference, and A's now static ABE interview. That is solid and unchanged evidence, even on A's case now. There is nothing new. It is unlikely because of the, and I don't want to use the word compartmentalisation, but because of the approach of a trial judge to anxiously consider the merits of each allegation individually before then not compartmentalising, which is not the correct approach, and putting it all together, it is unlikely to make a difference to the A outcome. And I say all this, my lord, and perhaps I should have said this at the start, we on behalf of F2, recognise and accept that whatever the decision of this court, he faces more allegations and will have to face them at trial. This court's determination is not an end to the factual issues in this case. It's just a question of whether there are two complainants or one. My lord, I hope that I think that does cover everything that I wanted to say at this stage. I hope that has...
Well, can we just cast an eye over your grounds of appeal?
Yes.
To see what I just want to make sure that we have clearly in our minds what was...
Page 17 of the bundle.
Yeah, ground one?
Gone for practical reasons as well. Forgive me, I should have updated the court. This morning, the case is listed before Judge Skellorn tomorrow for a read-only. Yeah. It is no longer opposed or contested. If this court makes a decision against dismissing this appeal, A will give evidence. The evidence has been coming in over the recent days, and Mr. Travers was able to tell my learned friends that that is no longer an issue, and we'll tell Judge Skellorn that.
Well,
so one's gone.
How does that make any difference to the question that we've got? I mean, it's very valuable to know that, in a sense, tomorrow it will take place but will not be contentious.
It's now a case management hearing in which Re-W will probably, it's obviously a matter for the court and not for the parties, but probably be confirmed. That A will get
so it'll be
unopposed.
If A is, I mean, assuming this goes ahead, it'll simply be to do with arrangements for the evidence and matters of that nature.
Indeed.
Rather than whether.
Indeed.
Right. So still help us as to how that bears upon the wrongness that's pleaded of going straight to reopening without doing Re-W.
I rely on 2 and 2 to 5.
Okay. So I mean, it always sounds terrible to say one abandons the ground of appeal, but you're no longer relying on ground one.
Indeed so.
Okay. And then casting an eye over 2 to 4, you've Mr. Travers has written about this.
Yes.
They say what they say. Is the argument that these were 2 and 3 were really factors that the judge put too much weight on, or shouldn't have put any weight on, or what is it?
Well, it's back to paragraph 74.
Yes.
The discharge is an appeal point, I say, not a reopening point, because the discharge is I do submit a procedural, not an evidential issue.
Right, so you're saying she shouldn't have put in this case any weight on?
Indeed so.
Right. Either the discharge or the criminal.
2 and 3 in that category.
Right, and then
4 I rely upon, and I say, in case management terms, without the previous finding, unimpeachable, but with that previous finding does not help with that expressed desire by the judge for having it all before her at the next fact-finding stage, does not help with solid grounds or what is new, or how is the result likely to be different. So I do say 4, I rely upon 4, and 5 is...
The judge's concern, as I read it, was that the existing finding in relation to A would serve as a fixed point when the court was embarking upon an investigation of a different landscape.
Yes.
That was really the concern, that it would mean that it was not possible to particularly to properly assess the local authority's alternative case against the mother as being at the root of all of these problems, not your client.
Well, it's only just an alternative case, dragged from the local authority as we read the judgments.
Well, that doesn't
But yes.
I mean, maybe they caught the train just, but
Just.
that was the situation that existed when the judge came to make her ruling. And so she seems particularly concerned by the prospect that she would be hearing the local authority's case against the mother, which was of alienation and putting certainly one of the children up to this, on the basis of a fixed point within the landscape.
Yes.
Rather than being able to assess the family as a whole.
Yes, but the fixed point, my lord, on that alienation side of things would be, in my respectful submission, that the binary return is nil only, not a finding by Judge Richards.
It's not -1.
Exactly. Thank you.
I don't think that's a binary possibility, but
Understood.
we know what we mean.
Yes.
So that, in a sense, it was a no-go area.
Yes.
That was the fixed point.
Isn't it? And trying to envisage that trial with D but not A before the court in June, that's quite normal. It's quite normal for an accused person to come along and not have findings or convictions that are relevant. That's the meat and drink of the family court hearing fact finds. And so the case, in my respectful submission, will in any event, because of the problems in the A case, rise and fall on the D allegations, which means that the D allegations can't inform, which means that the A allegations can't inform the D, because there are those problems identified by Judge Richards, and not because it's not new evidence, solid grounds for reopening those findings.
Could you just say again about the problems identified by Judge Richards, or all the matters that you mentioned at the beginning about how unreliable
Yes.
A is and so forth? But
Yes.
But it doesn't that beg the question that would arise on a rehearing, which is whether she was in fact unreliable.
Well, that evidence about her character and about her history as recorded by her
Yes,
mother,
it would all be matters that would be relevant.
and are static. That's documentary evidence given to a police statement. Static in the sense that those documents are static. Static in the sense that the mother's position has changed, but obviously then there'll be an exploration of credibility. Those problems aren't, because A is not saying I've got new evidence or I've got something new to say or a new description or anything new. It's all static.
I understand. Well, that's helpful to me at least.
Thank you, my lord. Can I assist further?
No.
No, thanks very much.
No. Thank you very much indeed, Mr. Tuan. Now, what I'm going to suggest is that we take a literal 5-minute break now, and then we'll hear next from Ms. Spills-Gold.
Thank you.
Attach myself.
You'll have us back in, won't you? So I put my hat on before. Oh, thank you. It's just so hot and it itches.
Myself some water if that's okay.
Yeah, that's
Parched.
because you've been doing all the talking.
Do all the talking. It's all the hot air.
Attached to it. I got up and I couldn't move. I was tethered. They had their 5 minutes. Just that.
No, not at all. It's good away.
I hate these lights. They give sort of headachy, these lights, aren't they?
Not very nice in here. Very hot.
Yeah.
This used to be the coldest court, especially last year in the heat.
Oh, lovely. Like everyone wants to come here.
And they complained. Then it went up.
No?
All rise.
Yes, Miss Nicola.
My Lords, may I start by setting out what I understand to be the appellant's position now, is that in terms of legal principle and the current law, there is no assertion that Her Honour Judge Skellorn erred in law, because the issue of RL, which seemed to arise and as a matter of interest, quite clearly, with Lady Justice King and any potential impact it may have, seems not to be pursued by the appellant, although it may well be that this court may consider, in terms of future guidance for the family courts, that a re-exposition of the what's called solid grounds, and I put it no further than that, and that what this court is faced with is the applicability of the facts of this particular case, which is set out in your Lordship's leading judgment of Re E and paragraphs 28 onwards, where you actually restate what Mrs. Justice Hale, she was then, said in the earlier authority of Re B. My Lord, if that is correct, then we are then looking at the area of discretion and whether Her Honour Judge Skellorn erred in her discretion. And can I start by saying that it was an extremely lengthy, or not overly lengthy, but a lengthy judgment, and carefully analysed not only the law but also the particular facts of this particular case. And I say that knowing that any application for a rehearing is always going to be case sensitive, and this is a complex family dynamic where we now have on the face of it allegations made by D subsequent to allegations made by A, and where there is criticism raised of Her Honour referring to the earlier judgment and decision of His Honour Judge Richards, and she does carefully analyse what happened during the criminal process as well as in the family process, she was entirely right to do so, bearing in mind that this court undertakes an inquisitorial role. The difference I would ponder in relation to private law as to public law is, of course, under Part 4 of the Act, the local authorities engaged in issues of child protection. And in order for the court ultimately to reach what the court hopes is the correct decision for any young person, it has to ascertain the factual matrix, and ordering of assessments is based upon a solid ground factual matrix. And if this rehearing did not proceed in the way it has been allowed for in June, there is a real risk that findings and ultimately disposal, I use that term advisedly, of the issue of D may be incorrect. As another point I would raise, and Your Honour, my Lord, of course, it has been raised, the issue of A. We now understand that A wishes to give evidence. That's probably neither here or there for this court. But what is important is the fact that in the hearing before Judge Richards, which took place, I believe, on the 26th of April, it was then a bank holiday, then the hearing started the following week. Yes, of course, in hindsight, there probably should have been an appeal against that discharge of A as a party, but that application was made orally, and of course by discharging A as a party, it meant that it wasn't simply, well, she wasn't giving evidence, but in fact she was no longer represented, and she had no voice within the legal process whatsoever. So, my Lord, in terms of discretion, I say boldly, Her Honour has not erred in her discretion in that regard. My Lord, would you wish, my Lord, for me to go through my grounds or our grounds of appeal?
Well, speaking for myself only, I'd like you to help in relation to the implications of for the proceedings that will be taking place of this reopening decision, both firstly in relation to the allegations against the appellant,
Yes.
with regard to D, and secondly the allegations against the mother,
Yes.
of essentially putting one or both children up
Yes.
to making allegations. So are you able to, as it were, just present the local authority's position and show us how the judge dealt with that?
Yes.
It's really the skewing point.
Yes. Well, Ron, the best way to look at that, if one looks at the judgment and starting at her analysis of this, and in particular looking at paragraph 71, which I think, if your lordships,
Yes.
my ladies, are working from paper copies, page 68, otherwise PDF I think is also 68. What she has done is interwoven the legal test with the factual matters in the particular case with which she is considering. And it starts with the phrase to the right-hand side on paragraph 71, in my assessment.
Yes.
And she refers to the interlinked issues. Now, later on, she rightly identifies, of course, it is possible for a judge to put to one side certain matters, but it does involve a certain matter of mental gymnastics. And in this particular case for the local authority, the factual background of A's allegations, what mother said initially of A's allegations, then later, according to Judge Richards, was supportive because he uses the phrase that her A's case could be put through the prism of the mother's case. And now we have D's allegations. In the meantime, of course, and I know that the chronology is not accepted, but in terms of the historical matters, we know that D ceased to have contact. It was that issue and what was then said which really prompted the local authorities' active involvement in this matter. And I have to say, hand on heart, it may well be that this court criticised the local authority for not having got involved at a much earlier stage, and we would have to accept that. But it is the panoply of issues facing this particular family which we say makes it impossible and in fact would not be doing justice to either D or indeed A or mother or father in this case if these matters are not looked at properly in the round.
Well, the judge refers to the global threshold exercise,
yes,
doesn't she?
Yes, and it is, my lady, yes, and it is an inquisitorial process. Of course there should be and there needs to be finality in litigation. People can't just live their lives thinking this and this is going to be relitigated over and over again. But in this particular case, no one is suggesting, were it not for D's allegations, this would have been reopened in the manner in which it has been.
Right, so one of the things that the threshold is designed to exclude is, as it were, sorry to use terribly lawyerly language, but sort of adventitious attempts to disturb settled findings.
Yes.
That clearly, the case doesn't have that flavour.
No.
Because there was a completely different reason why it happened in the first place.
Yes, my lord, yes.
So really the question turns towards, and I don't use this as a test as it were, the necessity of reviving the case in relation to...
Yes, that's probably the best way of putting it. I suppose solid ground. Is it necessary in this particular case for it to be revisited? And
well, I'm using that because necessary is a term of art in other contexts.
Of course.
I'm not anxious to set other hairs running, but in conversational language.
Yes.
If one is satisfied, and nobody was really suggesting that it was, to use my word, adventitious, that the question of whether there needed to be another look at A in order to reach a just conclusion for the whole family.
Yes. Yes. And so we say that there is, in this particular case,
of course, for us, the question is not whether there needs to be another look at A's case. No. For us, the question is whether the judge was entitled to consider that there was.
Yes.
Whether or not any view we might have, not for us to form a view about that.
But was she entitled to reach the conclusion that she did on the information before her and the arguments put before her? We say very clearly, yes, she was. And in fact, she analysed it all in very great detail, possibly more detail than many judges might have done so. She has carried out a very careful analysis of the law and balanced the competing interests and borne very much in mind, I would suggest, the fact that the father has been through a process and on the binary system he is currently 0.
Well, there's no doubt at all if this related only to the position of the father, one could have every sympathy with somebody who's been acquitted once, had a nil return at a family
Yeah.
court. If it was only about him,
Yeah.
one quite sees the point.
Yes, yes. And I don't take issue, and the local authority don't take issue with that. In fact, they wouldn't be involved to be saving the public purse a considerable amount of money. But we are dealing with issues here of child protection. And D in particular, you will have noted there are certain vulnerabilities, in particular for D, as well as what might be seen ultimately as a complex dynamic of the relationship of mother with A, D, and indeed both F1 and F2. So it would be artificial, in my responsible submission, for this not to proceed and for the court to allow the appeal.
Now, is there anything that you want to say about ground 5?
My lord, I think I've set out everything in ground 5.
Yeah. I mean, I think it's, in a sense, it's an opportunity, if you want to say whether, for example, the test as it's generally understood to be, absent RL, is causing anybody any problems.
Well, my lord, I can help you, I think, in this regard. And I say this in relation to Mr. Justice Mostyn. He has immense experience, and I have high regard for him. But when one looks at RL, one can see the way his mind, I would suggest, has worked when he is clearly looked at, in particular looking at the family court, financial remedy matters, Schedule 1 matters in relation to children. And we here are dealing with something fundamentally different. We are not the desert island, I would venture to suggest, but child protection is at the heart of what this case is about, and the test in relation to that must remain re-E and re-CDT. There's no good reason at all for narrowing it, which it appears, from my reading of Riel, he is looking at trying to narrow down the test, more akin to the Ladden-Marshall test, which one would be very familiar with in relation to financial remedy matters. It's not black and white in the area, in this current area, whereas in finance it often is far more so.
I mean, in fact, local authorities will, if anybody was going to want to narrow the test, it would normally be a local authority.
Yes.
Because it quite commonly might be a family member that had been on the wrong end of a finding, coming back and seeking to bring in new evidence.
And in fact, the other authorities referred to are very much in that vein,
right,
with non-accidental injuries, etc.
Right. But I mean, in a sense, I appreciate you're just the local authority that happens to be in this case, but this appeal offers you an opportunity, if you wish to seek to say that, properly understood, it does mean this.
My lord, looking at Riel, I don't see how I can say that. What Lady Justice Hale, as she then was, said in Re B, which has been adopted by this court in subsequent decisions, and in particular by your lordship, is very clear. Local authorities understand the test. There is no, as I understand it, no clamouring at the door to narrow the test further. The risk, if the court were to narrow the test, would potentially create grave injustices. It may well be Mr. Vine asks you to adopt a slightly different approach, but certainly across our local authorities, I've not heard of a clamour of, we're having so many issues with this, we wish the test to be narrowed. The test is very clear, it is very understandable, and I would say in this particular case, Her Honour Judge Skellorn fully understood it and balanced the competing interests and came to a decision with which this court should be slow to interfere.
Anything else, Ms. Holland?
Not at all, my lord.
No, thank you very much.
Can I assist you any further?
No, thank you. Thank you. Yes, Mr. Vine.
My lord, my ladies, good afternoon. We've reached the point through the exchanges that there's consensus between the parties, and I think with the court, that a factual determination can be reopened in the absence of an appeal, and that it can be reopened in the absence of strictly new evidence, both as matters of law. And as Ms Wills-Goldingham says, the appeal, as it's been argued now, is squarely about an exercise of discretion. My Lord, I would have a little bit more to say than has been said to you already about the reasoning section of the judgment from 71 through to 77. Not because I disagree with the submission that it's a balance of competing factors and therefore when you review it, well within the judge's discretion and with no obvious omission, but because of what is said in terms and how clearly the balance is struck by the judge on the specific facts of the case. Now, my Lord, if it assists to have counsel's observations on paragraphs, I'll give it to you, but otherwise I quite see the court can take those points from those judgments, or from those paragraphs.
Well, I think the submissions to and fro in relation to grounds 2 and 3 are, as it were, evident. We can gather those for ourselves. If you want to say anything supplementary to what Ms Wills-Goldingham has said about the what the hearing will be like with or without A,
yes,
as a the issue about A's allegations, she'll still be a party, whatever happens. Please do. If you haven't got anything else to add about that, then we can move on.
Well, my Lord, I will do in that case then, please, because squarely in paragraph 71, at 68, electronic page 69, it is the skewing point. I know the court has that already,
yeah.
But the rest of that paragraph deals with where the judge saw those allegations and the current determination of them sitting, in her words, at the very heart of the parental separation and dysfunction dynamics, which are central issues in the case.
Yes, towards the bottom.
Yes, my Lord. And you will have points already about assessment and balance and how the judge is striking the competing considerations. But those points are there, and they matter because when we come back to what I will have to say about the Nottingham case, or Nottinghamshire case, paragraph 71, the second part of it, goes to part of the re-E test when it's stated fully. That's to say the importance of the allegation in the issues before the court hearing the application. I think the court probably has, but might I give you, please, paragraph 18 of the judgment, which gives you a little more of the relatively unusual circumstances in which A came to be discharged as an intervener. Paragraph 18 is at, thank you, page 43, paper 44, electronic.
Yes. Yes, it's all set out there.
Yes, it's all there. I'd simply ask the court as well to have in mind not so much dates, but ages at the time of relevant events. At the time of A's complaint, she was 12 and a half. At the time that she gave evidence in the Crown Court, she was 14. And my Lord, it doesn't emerge with great emphasis in the judgment, but it's plain from the transcripts that she had not reviewed the videos of her interview.
Yes, we've read it.
You'll have seen that, but that is a, well, with the benefit of hindsight, that is a, if I can put it this way, it's a feature one might expect a family court judge to alight upon now. And thirdly, when she was discharged from, going back to ages, when she was discharged from the private law proceedings, she was 15 years old. She had no notice that the application was to be made. And within 2 to 3 days, a determination...
Well, she was I mean, of course, there's a spectrum in these matters, but she was entitled to be dependent upon her lawyers.
I agree, and I'm sure she was, but the reality is we don't have any information before the court as to what happened. I can't assist you with that. And there are points, we say, worthy of some consideration in the overall balancing exercise to be struck by the family judge considering whether or not to reopen. I'm just looking to see whether there was anything else I sought to draw out from 73 onwards. My Lord, I think I would wish the court to have that in our reading of the judgment, paragraph 76, paper 72, electronic 73, within the judge's analysis of what do you do with a witness who didn't give evidence and then seeks to later, the arguments, and this is a reference to the arguments that were before the court prepared by Miss Hoyle about A, wishing to give evidence. The appellant's points were squarely in the judge's mind. And it can't be said that they were taken shortly or with any more or any less care, in my respectful submission, than any of the other factors that were in the judge's mind when she struck the balance that she did. So, my Lord, that's how we would encourage you to read the judgment and the particular balancing exercise that was undertaken in this case. A little bit more, if you will permit it, on ground 5, yes, and where that leaves us. First of all, on the facts, in our analysis, although A's allegation was not new evidence, her willingness to give evidence and so the ability of a court to test that evidence was a new factor. And D's allegations were clearly new allegations.
Well, ground 5, it may be the case that we're not here talking about the authorities and all that. We're talking here about the significance of newness and what's got to be new, and whether it's appropriate that it's prescriptive about what's got to be new, but the new allegations, the question is whether those have got to be, whether it's got to be, as Mr. Tuan says, new information or evidence or information about those allegations in just looking at them. And is that what the law requires?
My Lord, not in my respectful reading of your two judgments in particular, but also what Mrs. Justice Hale said in Re B that was the foundation for those two decisions. And I say that in part, I'm prompting myself, but I turned my paper copy of Re E up. The heading of your judgment in Re E is further evidence. It's not new evidence, in a sense. Now, I'm not being semantic about that. And I know that when my Lord and I had an exchange in WA about the foreign convictions, one of the authorities that we looked at, it's not in our bundle of authorities, was a decision about a conviction where a father had admitted inflicting an injury and then gave new evidence that he'd been under duress to do so, or that he'd taken advice that it would result in a lenient sentence. And my Lord, that factor, or those facts, illustrate the difficulty of a strict, is it new evidence or not? There's new information, or in this case we would say, there's a new ability to test an old allegation. we will not trouble you by asking you to listen to a long extrapolation from me about what Re-E does and doesn't say. But my lord, it expressly starts at Ladd and Marshall, and what isn't the test in a case about in a children's case? Because it's perfectly clear, and in my respectful submission, settled. And just to give you the paragraph numbers on that, 23 and 29, that the strict statement of a Ladd and Marshall approach is not what is to be applied in any question of reopening determinations that relate to children. My lord will recall everything that you said about flexibility exercised in accordance with principle. So, on the law as stated in this court and by my lord, there is some tension between the language that is used in the Nottingham case, in my respectful submission, and the principle as properly stated. First of all, there's reasoned flexibility. Secondly, there is, and I'm not doing justice to either Re-B or to your judgment, but when I say the three stages identified in Re-B, and that's at paragraph 28 of Re-E, but I think we all know and see and have read. Stage one is the balance of the competing public policy arguments for finality litigation, for avoidance of error. Stage two is, and this is what I'd referred to before, the importance of the finding that's sought to be reopened in the context of the issues before the court on the next occasion. And stage three is the solid grounds for shorthand. And my lord, I don't know how you will leave these points in your judgment, but solid grounds alone, it risks being a dangerous shorthand for points 1 and 2 that are set out in Re-B and then Re-E, because this is about a balance of the competing considerations when a judge decides whether or not a determination should be opened or not. And then, my lord, I think the final point I asked you, well, no, the third point I asked you to have in mind on what has been said in the Nottingham case is that even viewed in its own terms, that's to say, I think this Willis-Goldingham took you to paragraph 43. The gloss, it's not the test that the judge identifies, but the gloss he applies to it is whether there are special circumstances which entirely change the aspect of the case. And in my respectful submission, that puts it higher even than Ladd and Marshall. Which is a more nuanced test than entirely change. Now, on a careful reading of the judgment, Mr. Justice Mostyn is not saying that the test is wrong, but those words risk misleading courts at first instance. And I do say, and Miss Wills-Goldingham has touched on this as well, the rogue castaway desert island point. I'm not sure that those submissions sit, or that approach or that criticism sits, with the points of principle that you identified in Re-WA on the foreign conviction. That's to say that the very nature of all proceedings relating to children, not just public law proceedings, but all proceedings relating to children, the very nature of the obligations of a fact finder to those who are before the fact finder, and the particular rules of evidence which apply in those circumstances. So, my lord, my ladies, those are the points we would ask you to take about what I do say in paragraphs 43 and 44 of the Nottingham judgment are paragraphs which risk being misunderstood.
I don't I don't know that the question really arose in that case anyhow.
No.
Yes.
My lord, I can't say to you that my experience is that re-E and re-C DT is presenting problems on the ground.
Well, we have obviously different constituencies, and our constituency is the permission to appeal mailbag, because that gives you an idea of what is happening in courts around the country and so forth. And so we're obviously, if there is a cause for concern, that's one way in which it comes up, because you tend to get repeated applications of the same kind around a point of law, and they usually end up with a hearing of one sort or another. Another constituency is your constituency, your clients and practitioners in the field, picking up that this is proving to be the sort of case where one counsel stands up and says it means this, and another counsel stands up and says it means that, and then that's not helpful.
And we haven't, before you, on the facts of this case at least, my lord, we've settled to a common statement.
Yes, well, and in the end, also the point that can't be missed is that the judge doesn't seem to have had any difficulty in deciding what she was meant to be doing. The concern expressed by the appellant is that she just got the wrong answer from that process. Okay. Yes, was there anything else, Mr.
No, thank you, my lord.
Thank you very much indeed. Mr. Toon.
Thank you, my lord. Unless I can assist further, I don't think I have any further submissions to make.
Thank you very much indeed.
Thank you.
Good. Well, can we thank you all for the preparations that have been made for this hearing? I include everybody who's present and has done the heavy lifting behind the scenes, and not just the advocates who've spoken. Thank you all very much indeed. We'll clearly be taking some time to give you our reasons, but what I'd like to do before the lunch break is that, because these are ongoing proceedings, is to take some time, if we can detain you, to consider whether we're in a position to give you our decision now or not. We won't use an outdated metaphor, strain to give you a decision, but if we can, I think there's advantage to you. May we go and see whether we are able to do that.
Thank you, Lord.
All right.
Yeah, I know. Right.
It is quite hot and dry in here.
It is.
Something about the lights.
Oh,
They seem to cause headache.
yeah.
Shall we step out?
Yeah, I just can see that managing that well. I've got some more I just can't quite see. Old. Got my glasses to see what you're about to imbibe. Ibuprofen, that will do.
You've got to do all this again tomorrow.
Oh, not me. Oh. Sorry, that's very selfish, isn't it? Not me. Not me. No. I go back to lambing tomorrow.
Wow, that's totally different.
Well, luckily, I managed to get my fingers clean, because before yesterday, my fingers were yellow. I looked like I had a 90-day habit because of putting the iodine on the umbilical cord of the lambs as they're born to stop infection. Yeah. It's all right. Okay.
their things anyway. So yeah. So they're coming. Did they say how long or?
I will ring and know what it is. Are they ready? Just got to pick out. Everyone in?
Oh, yes.
We haven't forgotten anyone? Haven't lost anyone?
No wrigglings. is
All
there?
rise.
Well, after what has been an interesting and well-presented argument, we've reached a clear conclusion. The outcome will be that the appeal will be dismissed for reasons which we will give to the parties in writing in as early course as we can possibly manage. And at that point, I know that the parties are familiar with the process. We'll seek your help with any editorial corrections, and we'll then hand down the judgments electronically in the normal way without the need to trouble you. At the time that you correct the judgments, could you please also let us have what I think is likely to be quite a short draft order. If there are any issues that arise on that, we'll obviously deal with them without needing to trouble you with any further attendance. Thank you all again.
All rise.
too late to say.